7 o'clock, it's heads up.
Hands up, hang on.
You're all set, John.
You're all set.
Who said so?
He said so.
He did?
Yes, he did.
You're talking to me.
You're live.
Tonight's agenda is a hearing on a variance of the minimum lot size for the Bushies. And there's a Harris's, represented by Mr. Nagel. The variance that they're applied for is they're in a agricultural zone now, agricultural and resident, of 80,000 square feet. The lots that Mr. Nagel is representing are 43,000 and 39,000 roughly. So they're asking for 100% variation. Mr. Nagel, if you're up.
Okay. Thank you. My name's Chris Nagel, and I assume this is where you want me to stand.
Yeah.
Okay.
Yes.
I'm happy to
Yeah.
sit down. Quickly about myself, I'm a lawyer. I practice in Portland. I've been doing that since 1977. I do mostly real estate work and land use work. My experience with this kind of stuff is I do represent a few small towns scattered around Maine. I am on the Cumberland Planning Board, so I sit where you do more often than I sit where I am. So I have some appreciation for what you're up to. And my family is one of the Spillers from the Wells area. But I'm here on behalf of two different lot owners. One of them we collectively call the Boucher Estate. And 6 of the 7 children are with me, and a husband and wife or two. There's Gaston and Isabel Boucher, who owned these lots for a long time, as well as Dean and Wendy Zaharis, who bought a lot from them a couple of years ago, and they're also seeking a variance. I assume you saw the stuff I mailed you, so I'm not going to go over it in great detail, but I guess for the benefit of the public, which may not have seen it, I'll quickly go over the highlights. Before I do that, I want to make sure we all understand the plans that are involved here. Exhibit 2 to the application is this reduced subdivision plan. This is the second time the planning board approved it. I didn't bother to include the first one since it's the same except for this restriction about tree cutting on the beach area lot. So this is the key to our argument. It's a copy of the plan that was approved by your planning board in April of '75, and it divided a chunk of land into 7 lots that were perfectly legal at the time. The other plan I just wanted that I'll discuss is Exhibit 1, the version of your tax map 37. It's not too hard to see where the subdivision plan sits on that tax map. And this map also goes on to show how the road continues down towards Lossipee Lake. That plan, I'll get to it in a second. So that's just the plans and kind of where we're starting from. So just to run through the history, it all started in 1970 when Mr. and Mrs. Boucher bought a camp on this lot numbered 7 on the tax map, which was a 75 by 75 foot lot. And I suspect the people in this room could tell you a lot of stories about what went on at that camp, since I'm guessing most of the kids spent a lot of their time in the summer there, and it was one of those great places that families enjoy. So that was great. 4 or 5 years later, the planning board approved the land kind of behind it into a subdivision of 7 fairly large lots compared to certainly the existing neighborhood lots. They were all roughly an acre in size. And as you can see, the 7 lots were created in 1975, originally in 74. Another developer bought some of the lots, got it reapproved in 75. That's the plan you have. And in 1975, Mr. and Mrs. Boucher bought 3 of those lots from the developer to protect the woods behind their house as an investment for their future, and for all the reasons people buy some land. But at the time, they were approved planning board lots. And since then, 1975, that's now more than 30 years ago, they have been paying taxes on those 4 lots as 4 residential lots. Later in 75, the 4 lots on the road got sold. Lots 1, 2, 3, and 4. They got sold to different people, and each of those people put a house on those lots. The next event that's important is that in 1977, the town adopted or amended its zoning and put this land in the agriculture and residential district. It basically calls for 2-acre lot sizes, where each of these lots had been created as a roughly 1-acre lot size. There was really no provision in that amendment that allowed for lots the planning board approved to be developed anyway, notwithstanding that happens in other towns. I'll talk about that more. There was certainly no notice sent to the Bouchers that their lots were somehow being stuck together. And even after that change, the town continued to tax the Bouchers for each of the 4 lots separately. So life went on, more or less without any problems, for another 20 years or so, with them enjoying their property and their family growing up, etc. And eventually they got old, and in 1999 Isabel passed away, and her husband Gaston became the owner, and then 4 years later in 2003, he passed away. And his estate is still trying to liquidate this property. 3 of his children were appointed personal representatives. And in the next year, in April, they sold, first of all, Lot 7, which is marked Hurley on that subdivision plan, to John Hurley. And they sold that camp lot that they had owned to John and Angelina Hurley. And I don't know if the Hurleys are here or not.
No, I'm here for that.
You are here. Okay. I won't speak for them. I did send them a letter about this application, but I don't represent them, and I'm sure he'll say whatever he needs to say. And then in September, the Harrises were interested in buying some property in the summer, of 2004, and they looked into it, and they actually went down and talked to your code officer, or talked to the secretary about it, and my application talks about that issue. I really don't want to get into it. I recognize that your lawyer has written a letter saying it's not something you need to consider tonight, and I'm not here to argue that at this time. If we can get the variance granted, none of that's really important. But certainly the Harrises will tell you they did everything they thought they should do and bought the lot in July. And then a year or so later, September of 2005, the code officer sent a letter to my client basically saying that these lots had been, well, it speaks for itself, it's part of the application. I think the bottom line is she felt the lots weren't proper lots because they hadn't been approved for the division. And they didn't meet the zoning standards. And I know she's got a material for you, so I'll let her speak for herself on that. But certainly the bottom line was the lots weren't buildable. My clients came to see me this fall about what to do because initially the Boucher family hired me. They had their lot on the market, lot 5, and their buyer was understandably concerned about these letters. We contacted the Harrises and the Hurleys, and the Harrises decided to join in the appeal. So there's different things we could argue about, and I would rather not. as I alluded to, just the question of the reliance on the conversation with the code officer. I guess there's some question, at least one of the lots might be outside the shoreland zone. You can even make an argument that there is a grandfather clause, but it's somewhat gray. So I think the simplest and cleanest thing to do is to seek variances for these lots. I know that generally variances aren't easily granted, but I think this case certainly meets the standards as I read them and is a perfect case to have some variances granted. I think the important thing to remember is your planning board reviewed this land and this development in 1975 and approved it as 7 lots. And my clients just want to use those lots the way they were approved by the planning board. So, to get an undue hardship variance, which is kind of the classic variant, it's one of the 2 variances in your ordinance, it's defined also by state law. As you correctly stated, we need variances, ballpark 100%. One of our lots is 44,000 square feet, so we need a 35,000 square foot variance, and the other lot is almost 39,000 square feet, so we need a 41,000 square foot variance. In simple terms, my client's lots are roughly an acre, the zoning is roughly 2 acres. So, what do we do? If you meet the 4 criteria, then the zoning board can give them a variance. So let me address each of those. One is that the owners need the variances for the lots to have a reasonable return. And I think it's pretty obvious that a house lot that you can't build on just won't yield a reasonable return. No one's going to pay the kind of money that a house lot is worth if you can't build on it. The town has stated it won't issue building permits. But the town's been assessing real estate taxes on these lots as residential building lots since they were created. And the lots were approved by the planning board in 1974 and again in 75, according to the land use criteria in your ordinance and the state law. So if they can't be built on, they can't have a reasonable return. If we get a variance, they will have a reasonable return. There's really no kind of halfway. We need to show that there are unique circumstances, and I think that's pretty true. They're the only 3 vacant lots in the neighborhood. Residents have already been built on lots 1, 2, 3, 4. There are at least 6 other residences in the neighborhood, all of them on lots much smaller than these 1-acre lots. And I don't pretend to tell you that the location of these buildings on this plan that I sketched in suggests that's where the buildings are. It's just to show you that that lot has a building on it. The building could be really anywhere within this, so I don't want you to be misled about the configuration of the buildings, but there are 6 other houses down there, including the Boucher's originally camped, that are on, very small lots, 1/3 of an acre or less. So, these lots are unique because they're unbuilt. Another thing I guess that makes it unique is that your zoning ordinance doesn't have a pretty common non-conforming lot provision for lots approved by the planning board. And I gave you copies of ordinances from Arundel and Kennebunk and Saco and South Portland, each of which says in their ordinance, well, if you've got a lot that's approved by the planning board, you can build on it even if it's not up to the minimum lot size standards of that zone. It's just common sense, and I think part of the reason you don't have one is no one's really asked to put one in before. Imagine it's the kind of thing that could get through a town meeting if you had to go so far. So we think there's some pretty unique circumstances. We need to show the essential character of the locality will be unaffected. And this is in a residential neighborhood with residences in it. There's already 10 other residences on lots on the same size or smaller. And the common lot on the lake means that really there won't be any shorefront development. So we don't think the essential character of the locality will be affected. And we need to show that the need for the variance wasn't self-created. Well, I think it's easy to see that it wasn't due to anything done by the Bouchers or the Zaharises. It was the town that rezoned the land. And again, the town never sent the Bouchers a notice saying, You're now in a different zone. They never merged the lots and charged one tax bill. They continued to assess them as house lots and pay taxes on them for more than 30 years. And the Zaharises really looked into this issue and made a good faith attempt to figure out things at Town Hall, and were apparently given some bad information. So none of this was really anything they did wrong. And so we think this particular application meets those 4 hardship criteria. And we would respectfully ask that you grant the variance as requested. I know they're bigger than the 15% that some of your ordinance talks about, but that's not an absolute limit. And if you agree that these variances can be granted, then I don't need to talk about some other arguments that I think we could make if we needed to. For example, the Zaharises' lot is, the Boucher's lot's outside the shoreline zone, and you could use a practical difficulties type variance if you wanted to. But we think it's a pretty simple, straightforward case. We hope you agree. My clients are all here to answer your questions, if there are any, and thanks for listening.
Does anybody want to speak? Bushies or your clients? No? Okay. How about anybody else? Neighbors?
Oh,
Yes, sir.
maybe a couple of comments.
Yeah?
I'm sure they're aware of that the front of their property, the Zaharises, a lot of it is part of that turnaround. Probably at least 50 feet of it is part of the turnaround, and there's quite a bit of height that will have to be corrected in order to get a driveway in that property. And also, I'm here to make a statement, there's a lot of small camps in the area. Practically, a lot of the lots probably wouldn't be granted any variances today because they're so small, they wouldn't support the septic system and the well. And I just hope that you guys have looked at that scenario, that that small lot supports the septic system and the well without adding to pollution in Osprey Lake. That's my comment. Thank you.
Thank you.
My comment is on my lot, my well is 15 feet from my property line.
You are,
You are Wade Woodbridge.
and where are you?
I'm number 4.
Yeah.
Okay, yes, I know where you are, yep.
And it sits back quite a bit on the property line. It's actually 27 feet from the back of the property line and 15 to 17 feet from the butter's property line, that Bushies.
So you're talking like up in the back corner here?
Yep.
Yep.
And the other thing is when the real estate broker contacted us about her sign being missing after my house got broken into, we had also told her that she might want to be checking into whether these lots were buildable or not. And they were told long before the lots were sold that these might have some problems and they might want to get stuff in writing. I mean, I can come down here and say that I talked to somebody in the town hall 5 years ago and they told me something, but it don't hold water if I don't have it in writing. And the other thing is that we were told that it was not the real estate broker's problem that the lots weren't conforming. It was the problem of people buying the lots. Well, I think that's something that the real estate commission's gonna know about, because I don't think it's right. I think somebody should have checked with the town first and solved all this long before this ever come to the zoning issues. And that's all I have to say.
Thank you. Paul, you're a neighbor? Nothing?
No. If I could just briefly respond to those points. With respect to the need for septic system the first gentleman raised, clearly someone's going to need to do a soil test and it's got to need to meet the state requirements, and that's something that the code officer will review if and when an application is filed. So that's really not something we need to worry about tonight, but that needs to be done. And in respect to this gentleman's well, that's good information. I'm pretty sure that no one can put a septic system within 100 feet of your well. And that's one of the things that a site evaluator has to do when they go out in the field. So there's already state law to protect you, and the septic system on that lot will have to go somewhere away from your well. And there may be more details. But those are issues that are addressed when people file the application for the building permit.
So you'll contact all the abutters?
I don't, in most cases, when someone applies for a building permit, abutters are not contacted, but you may have different practices here. It's one of the kind of problems to the permitting process, in my opinion. But typically, if someone walks in with a permitted use for a lot that's conforming and meets all the setbacks, they get a permit. And
Probably know what a setback is. My point's buried in the ground.
Can I speak
well,
to
the
that?
surveyor will, the soil crew will find it.
They do
Yeah.
make every attempt to locate the wells based on the property owner's information, the abutting property owners, because it's their license to make sure that they're 100 feet from all the wells around. You know, they have to certify it meets code too.
But I guess I want to say I certainly respect the right you have to protect your well, and there are laws, and my clients can't do anything to adversely affect it.
I guess, excuse me, Paul Quisman, I'm in a butter directly across the road. I have a comment and a question. I am concerned about the runoff towards the lake. The ground slopes down from that property down my gravel driveway, and I had a flood last year. My cellar was flooded. So I'm concerned about runoff from that kind of development. I'm also wondering what the status of the road was when these properties were for sale. Attorney Nagel, can you comment on that?
I really don't know whether it was a private road or a public road.
Yes.
I don't know.
Does anyone else in the room?
Nothing has changed.
Meaning it's always been private?
Yeah, yes, and it's always, the road has always looked as it looks today.
Okay, thank
Sounds
you.
like it's been a private road instead.
It became a public road just this July, is my understanding. I received a notice from, the town, but
No, it's just the opposite. It has been a public road. It has been maintained by the town since 1969, and that's plowed and graded and sanded, and it was approved on the town Bible as an approved road.
Can we
They have
stay- can-
reversed, finally, the town has.
Paul?
Pardon?
Can we stay with the variance, please?
Yes, you may.
Thank you very much. Any questions?
No. It sounds like this is on a hill.
Yes, it is.
It is high.
It is on the-
There's no thing here showing the grades or
No.
because
There
of
isn't.
water and.
What was the question?
Is it on a hill?
Hey,
The lots are on a hill.
The hill slopes down towards my property.
Slopes towards.
Route 5.
We already have flooding problems.
Down that end of the property, that's why my well's down there. I don't have to worry about water.
It's also inclined on my property.
Oh, definitely.
If there is no more comments, yep, yes, yep, yes.
Mr. Hurley has a lot that he purchased. He purchased the camp in the front. It was 6 on that sheet right there.
Yep.
And he's got the largest lot basically out of there. That's why he bought it, right behind the camp that he bought. For an investment, privacy, people out of the backyard. It runs right directly behind the camp. And he was just pretty much sitting and wondering if he was going to get a variance. Does it affect if they get the variance? Does he get the variance? It's the only question I really have. It was the largest
Each case
lot.
would be different.
Each case will be individual?
But, you know,
Okay, so,
can I say something
Yeah.
about that? I don't know how you guys see this, but if you grant the variance on the front 2 lots,
On
doesn't that by default leave that one on its own? So it's sort of encompasses all 3 of them. I
Yeah, to
think.
me, if
That
you
was
give
my
one, you're
understanding.
gonna give them to all the rest of them.
okay. That was,
I mean,
Legally, I would say that it would stand on its own merit because you have to come before the board.
Yeah, you just couldn't say, well, my neighbor got one, that means must be
No,
I'm
no.
gonna get one, I'm gonna run out and do whatever I need to. No,
So you have to file the application also for a variance, correct?
yes.
Okay. Thanks.
Any,
If I could just briefly address this last gentleman's comment about the stormwater. I mean, that's one of the things the planning board looked at and approved, so I don't think you need to revisit it. I sincerely don't think 3 new driveways are gonna cause a serious problem, and if it does, my clients will have to fix the problem anyway, so hopefully that won't be a big issue.
Kirby owns this one.
what's that?
You're telling me Kirby owns this one and this
I
one?
think so.
Okay.
I'd like to make a few comments before we move on, John.
Okay.
I'd like to reiterate the lawyer, Mr. Nagel. I thought the first time he mentioned that the lots, although he could have been speaking strictly on one of the lots, wasn't in the shoreline zone. Lot 6, of course, is. He mentioned it later on in the case. Lot 5 isn't, as far as I can tell. The question to Mr. Nagel is, since we're going to deal with both of these lots at the same time, you want to use the 4-part criteria for both those lots?
Yes, I do. I think it's simplest. I think the one outside the zone could also meet that other test. And I still think this meets this test, so that's the best way to proceed. I think it's the easiest way for the board to consider one variance for 2 lots.
The second thing I'd like to bring,
If it's denied for some reason, we'll talk about the other option.
the second thing I'd like to bring up, John, is Waterboro enacted the zoning in '77. I can see for a reason. Unfortunately, this subdivision is probably not very unique to Waterboro. It might be unique this year. There's a few of them out there that are grossly undersized, such as this. We're talking a 100% variance, or close to it. State
Doesn't have anything to do with that variance.
and town manuals do not recommend that big of a variance. They tend to be in the 15 to the 20% range. And I just want to make that comment. Everybody would take that into consideration before moving on to the 4 criteria. And I think a lot of the 80,000 square feet has to do with protecting your neighbor so that you're not drinking their septic system. And I'm a big believer that you need a little bit of open space if you're going to have a well and a septic system on that lot. The city of Westbrook, the city of South Portland, some of the cases that Mr. Nagel provided, where they go back and you can call it grandfather if you want, or they allow building on substandard lots. Generally, they have sewer and water, so it's not an issue. And then we can move on into the situation where the state recommends that undersized lots, if they're owned by the same person, they really should be combined so that they're conforming. So I guess I've said my piece. If anybody has any questions, I'd be glad to answer them.
If there's no more questions, we'll close the meeting to the public, or cover public comments, and we will vote on the 4 criteria. Are we ready for that? No more comments?
I am.
Huh? You ready?
I'm ready.
Okay.
Somebody, I got people on the-
I think as far as the well and septic, that's why they decided to have a 100-foot setback from your well to your septic. If they meet that criteria, then you're not drinking anything but your own water, because they built this through. Mr. Hurley did a drug test, but they didn't do any paperwork. It was all gravel and sand, which was perfect. I mean, it was just a basic system. It wasn't anything that was absorbing it out of the ordinary.
I'm not arguing the 100-foot set in the study.
Yep,
I'm saying that the town of Waterboro,
yep.
more than likely, I wasn't here at the meetings in '77,
Yep.
got enough foresight to make 80,000 square foot lots in those areas so that people have a little bit of room
Mm-hmm.
to place their house, place their septic, and place their well, so they're not interfering with the neighbor. And that's all I said. I'm not here to argue on what's safe and what isn't safe. I think they probably chose the square footage with a little wisdom so that they had that flexibility, so that if you were tight, you got that little insurance.
And if I could just add one last comment, I respect the points you're making, I think they're good. I just want to point out that the state minimum lot size law for houses on septic systems, for towns that don't have zoning, is 20,000 square feet, half an acre. That's the state law. You can't build a house with a septic system less than that, no matter what the town says. So these lots are twice as big as the state minimums when it comes to septic systems.
Any more comments? We will close the comment period. We'll go on to the criteria. Number one, is the land in question cannot yield a responsible return unless the variance is granted.
We've had a few workshops here about that certain question, because that question has been asked quite a few times. What is a reasonable return? And we've
Lake
had-
Arrowhead is full of them.
And we have had people come and say that, well, if I can't sell this piece of property, I feel that's not a reasonable return. Well, our lawyer has told us more than once that if you can use it during the day for a picnic area, that's a reasonable return.
Comment? How do you feel? You vote?
I'm ready to vote on
Okay,
number one.
all right. Those who vote that it can not yield a reasonable return. Those who can, who feel it can return a reasonable return. 4-1. The need for a variance is due to unique circumstances of the property and not the general conditions of the neighborhood. I didn't see any information in here that would indicate that there was any unique circumstances of the property.
Actually, they're all around the same size if you take them all into consideration.
Yes.
The only difference between these two lots is they never built on.
So the need for a variance is due to unique circumstances is, again, the property is not general conditions of the neighborhood. Those who feel that it is not unique, these questions are terrible. You vote yes or no. The need for a variance is due to the unique circumstances of the property. How do you vote?
I vote that has been met.
It has been met, yes.
It has not been met. It is not unique.
I vote that it's not unique.
Not unique. The vote is 4-1. It is not unique.
Where's the fifth person?
You can't add. That's
I'm just curious.
When you say
4-1, I see.
3. What, this one here?
Well,
You said 4-1.
I'm sorry, there's only 3-1. No. Number 1 was unanimous. Number 2 was unanimous, 4 votes.
Okay.
That it is not unique. The granting of the variance will not alter the essential character of the locality. Comments on this?
No comments, John.
No comment.
Okay. The granting of the variance will not alter.
Now, do you want to hold a vote on the essential character of the, three?
Criteria number 3,
Yeah.
the granting of the variance would not.
Does it say how to read it, right?
Essential character of the locality would be unaffected.
The character of the locality would not be affected, so I would vote that the variance would not alter the essential character of the neighborhood.
Probably not.
Right.
It probably would
I
not
would
change
say-
it.
I would say to keep it simple, my vote would be that they've met
Yes,
number 3.
yes, it would not,
Criteria.
yes.
And I vote they have met criteria number 3.
Yes, sir.
Right.
Yes,
4-0.
4 and 0 on that. The hardship is not the result of action taken by the applicant or prior owner. The applicant, as stated previously, that in 1977, we had a change in ordinances, and whether there's anybody here that says they didn't get a notice of that, it's immaterial. The lots are non-conforming, and in fact, if these are, comparing these to the other ones, they were all built in, prior to 1977. So I believe that the hardship is the result of applicant or prior owners, is that they had a chance when the zoning was changed to take action, and it has not been done.
I have a comment on that, John.
Yes.
I disagree with that. I believe they've met criteria number 4. They haven't self-created it. And if you'd like to, if anybody wants to take a look at the state manual, page 51,
Section.
you take a minute to read it. You may agree or disagree. It's under page 51, state manual, state
That right.
standards.
I have a local one.
I'll be ready to vote when everybody else is done. The applicant or the prior owner, the applicant purchased this land 2 years ago. These regulations, town rules were in effect at that time. And non-conforming lots. It's not against the law to buy one, it's not against the law to sell one.
purchased in '05?
Oh, four.
'04?
I didn't get one in '04.
It was on a sheet
'04
of
here,
five.
'04 here.
So the prior one, and
But it was
I
a
would
long
say-
time after the zoning board passed these ordinances as a conforming lot or non-conforming lot.
So,
The problem we have here is that the variance is driven by the square footage. And it could be that all parties involved weren't aware that they were substandard lots. Any and/or. And the way I see it is that excuse me, let me reiterate on that one. Well, let's just look at it. It was driven by the square footage.
What they're asking for is a 100% increase in square footage.
The Bouchers and the Zaharises didn't create the square footage, and that's the way I look at it. It was subdivided. They didn't create the square footage problem. Whether they bought, sold to 10 different people, it doesn't matter. They're not responsible for the square footage.
Okay. So we're ready to take a vote? Yeah. The hardship is not the result of action taken by the appellate. Those voting that it is not their action.
I'm voting that they met criteria for, that they weren't
Okay.
responsible.
All right, those who have met criteria for, raise your hand. One. Opposed, did not meet criteria for. 3-1. The issue here is that you need to be approved for all 4 criteria. The board voted for 2 out of the 4, so therefore the variance is not granted.
Can I pursue 2 other arguments that we raised?
To argue, the variance is not, are we on the variance?
Well, there's the practical difficulty variance.
Practical difficulty.
It's a different kind of a variance, which the Boucher lot could apply for. And since we're all here, I would like to talk.
Could I interrupt you for a second? I specifically asked you before we went into the process, which you wanted to pursue.
And at the end, I said if we lose this variance, I'll pursue the other one.
Before you speak, are you talking about going to an appeal? Administrative appeal?
I'm talking about you're considering the practical difficulty variance for the Boucher lot. And I would like to at least make a brief statement on the administrative appeal that your lawyer says you shouldn't be hearing. It won't take a long time.
The administration appeal is for the, is for what? Because
It's part of the application.
it's not in our realm of, what are you appealing?
Well, we're appealing,
Yeah.
we're asking for an interpretation of the ordinance.
Okay, that is not our,
It is.
You can take an
Right.
interpretation.
Well, let me just, I think it is. And lawyers have different opinions all the time, and that's okay. We wouldn't be here if we didn't. But your ordinance gives you pretty broad powers to decide things. And I guess I wanted to give you an opportunity to at least consider this argument and see if it changes your mind.
Excuse me. I have a question. We already voted on the variance
yes,
Yes.
tonight,
yes.
so there's no,
I don't know what he's doing.
Well, we also filed an administrative appeal.
Yes,
Well, the variance is closed.
I hear you.
yes, yes it is.
variance is over.
This is a dual application.
Yes.
She
Okay.
applied for two separate types of reviews by this board.
Okay. We're just not used
Which
to
one
it
did
either.
you just deny?
It's
Now-
uncommon
It's
with
very uncommon, it's their first
Yes.
time on this one.
It's,
My-
it
my
may be
first time.
uncommon,
It's a
but it's
two-party
perfectly
and it's-
legal.
acceptable.
Oh, yeah, oh, yeah.
Yes.
It's two party in the same application?
Yes.
Which party did we just deny?
No, it's the
No,
same
it's-
two parties on both applications. It's two
Yes.
different theories.
Okay.
Which is,
Excuse me for just a second while I dig out your part two. I'm having trouble locating it.
I'll show it, see it. This here, you got a copy of this.
Yeah, I really wondered we could stop it.
Yep.
Find it? You don't have it either? Part one was the variance, joint variance request.
Oh, it's in this.
Part two is in the back.
I looked at it and hadn't come into the room. Okay, here's one.
Can you find it?
On the attachment to the
Right
variance,
behind part one,
it's on page 4.
right, four.
Oh, I have it.
My code enforcement officer should have her speak first, because you are mentioned in here as that the board cannot hear administration appeal in the absence of an appealable decision by the code enforcement officer. Have you issued a decision?
Well, can I speak to that letter,
Yeah.
the attorney's letter?
Yeah.
My discussions with her on how I understand it is that if that is what is being asked of, and I'm not sure that, it doesn't sound like it is,
Okay,
then, because there is no decision,
right.
if the zoning board always has the right to make an interpretation of this
Yes.
section of the ordinance, and I believe that's what she's asking for from you.
Okay.
On the interpretation of section 905, I think that's my understanding of it.
That's correct. We're not appealing her decision. You see, we checked the other box on the application, and we're asking you to interpret the facts in the ordinance to give my clients the practical relief that they really deserve. So I
905,
I think it's appropriate, as part of what we appealed.
that's what he's,
So if you want, I can
proceed.
proceed.
What, wait a minute.
I don't mean to interrupt.
Yeah.
Just to keep things clear for our records and in case this goes any further, can the board vote on whether this can be reviewed under the practical difficulty standards?
Where are they?
Those are for the lots that are not within the shoreline zone, section 10, 4,
Okay.
2,
That's in section 100402.
Variances and dimensions requirements?
That's it. It's what some people call the practical difficulty variance, because as you just determined, sometimes even common sense is hard to meet the standards of things like reasonable return. Reasonable return's not part of this variance standard. And it was my intention to talk about this before I talked about equitable estoppel, and I thank the code officer for at least making a clear record on whether you want to hear this or not.
I think, I'm sorry to interrupt.
No.
That it will leave room for a reconsideration request if we don't do it. So at least consider doing it now, because if it were me, I would just ask for reconsideration, and you may be able to do that right now. Review that second set of criteria. It might save you another meeting.
I agree with her. If we can get all three decisions, then we don't have to come back to this board in a piecemeal fashion.
I'm missing something here. 10.4, section 10.04.
Point 2.
Point two.
Point
Point
two.
two.
Yep.
Variances from dimensional requirement.
Mm-hmm.
That's what we're looking at.
Mm-hmm.
Which that is one of the dimensional requirements, the lot size.
And they have to meet all six?
Yes, in order to get the variance.
Mhm.
It's a different set of standards.
Well,
Number 6 says it can't be in the shoreline zone, which knocks as a Harris lot out.
Right.
That thing is in the
In whole or in part?
this is exactly the question that I,
It is.
first of all, this is exactly the question I asked Mr. Nagel up front. If he wanted to consider this option, or whether he wanted to go with a four-part criteria. The second thing we run into here is, right off on question 1, I mean, we can consider it.
But number
If
one
the
is,
group wants to,
we already voted on one. and
but
it's
we've
just-
already voted
the
on
same
a similar,
question.
or the same question, and even though it might be worded differently. Now,
As long as it's brought up and discussed and voted on.
Okay,
that's-
then that's what we should do?
Right.
Then that's what we will do.
No, I mean, as long as you guys discuss
East.
whether you're gonna use these criteria or not, and then vote on it, I think we're covered.
Okay, because this is, like I said, this is something different, new.
So this is the secondary part of the,
This is
No,
this is the
he
middle,
had-
this is
he-
the middle part. It's the second part of the first part.
He had a choice, from what I understand, to either take these 4 or these 6.
Six.
He didn't like the answer on the first 4, so now he's gonna take the second 6?
and that's what he's gonna take for an answer.
Well, this gentleman asked me point blank, as he stated, did I want to go into these criteria, and I said no unless we lost. That's what I said.
that was a misunderstanding on my part then.
Well, that's what I said. You can roll back the tape. I'm sure that's what I said.
That is what he said.
And since we lost,
So you'd like to roll to the 6 criteria for lot 5,
yes.
and not lot 6?
Well,
Because
Code
lot
officer-
6 is in the shoreline zone.
I think lot 6 is in the shoreline zone because it appears, if you look at the dimension on the north, it's less than 200 feet away. Part of it outside the shoreline zone, but a lot of it's inside the shoreline zone, and the standard says the property is not located in whole or in part within the shoreline zone, and I can't sit here with a straight face and tell you that I think lot 6 is totally outside the
Well,
shoreline
the
zone.
plan that was submitted to us, it's just, really a hypothetical plan that's for tax purposes or something. It's not done by anything. It wasn't surveyed, it wasn't brought out to anything. Or
This was surveyed and approved by your
This one
planning
is,
board.
this one is.
which one is?
This is,
Right, but it's showing you inside the property line, right? Inside the shoreline?
no,
Which one are you on?
I'm on the survey plan, it shows
One
lot
or
5
two?
is
Two?
way out,
6,
lot 5,
The one
exhibit
done,
2,
Exhibit
the
2.
one done in 1974.
correct.
Okay, the one that says this is in joint butters with 7 in this other lot, each area to be owned jointly. That's the one you're talking about?
I'm not sure where you were reading, yes.
Right up there.
Yes. And I'm
Okay.
saying that lot 5 on that plan is outside the shoreline zone.
But you're
That's the
not
lot
sure.
that's owned by the Boucher family. Lot 6, which is owned by the Harris family, is partly inside the shoreline zone.
Which one did the Boucher own on the street?
Boucher owned 5, 6, and 7, as well as the camp once upon a time.
Which was, what number?
The camp wasn't
5, 6,
numbered,
and
it's
7.
labeled Karen, so it just says camp, it's just bottom of lot
Oh, it's on
7.
this one?
Yeah.
Okay.
Oh,
So, I respect that some of the standards are similar, and this may not take long if you don't reconsider your positions, but I would like to do it while we're here. I think your code officer suggested it's a good idea. If you determine one of the standards hasn't been met, then you don't need to consider the other ones as far as I'm concerned. So if you can just let me quickly address these and try and change your mind on a couple of points. Unique circumstances. When you look at Lot 5, it's the only unbuilt lot here that's outside the shoreline zone. That makes it unique. 6 and 7 are still in the shoreline zone and have different issues, but Lot 5 is outside the area that people deem as environmentally sensitive, and that makes it unique. Number 2, it won't produce an undesirable change in the neighborhood. Adding another house to a neighborhood that has 10 already isn't going to do that. And it won't unreasonably detrimentally affect the use or market value of abutting properties. I don't think adding a house in a residential zone where all the lots are about an acre will do that unreasonably. Number 3, the practical difficulty is not the result of the action taken by the owner. Again, this is the practical difficulty, not the hardship. And I have a hard time seeing how the Bouchers did anything, or the Harrises did anything. Again, the Harrises went to town hall as you would expect them to, and got some bad information. Now, that's not anyone's fault, and we're not here to point fingers, but
do you have that information?
nothing
Not
was
you
given
do.
in writing.
Okay, thank you.
But again, this is a result of a rezoning of some land. I think it's significant to note that the town still assessed my client as residential lots for 30 years after they changed the zoning. And they didn't give them a clue that those lots weren't buildable. So, I don't think it's anything they did or they had a good reason to know about. Tax bills didn't change. They pay taxes to the town for a long time on lots you're now telling them they could never have built on. No other feasible alternative is available. I don't know any other way to make these lots buildable. The variance won't unreasonably adversely affect the natural environment. Again, outside the shoreline zone, 1 house on 1 acre, hardly going to do that, and it's not in the shoreline area. So at least we would hope you'd consider a variance for the Boucher family for Lot 5 under this practical difficulty standard. Thanks.
I'm going to add a comment here on 1004.3. additional variance standards. Number 3, a variance, if granted, should necessitate only a slight departure from the stated requirements of the ordinance, usually not exceeding 15% increase or decrease.
You could add criteria number 4 to that, John, if you want, which is not the intent, subvert the town's comprehensive plan, local subdivision regulations, or ordinance.
Well, I guess just to that point, members of this community sat around this table, and probably a different one, in 1975, and approved these lots. Now, I don't understand why this town doesn't seem, at least this board doesn't seem to be giving much deference to what your predecessors did in this town. Those people sat around a room, had public hearings, considered environmental issues, septic, runoff, and they approved these plans, and they let developers sell lots to people. And you guys assess them as residential lots.
And some of the, not
And
very-
so to say it somehow doesn't comply with the comprehensive plan or the planning board process, I think defies the facts. And I guess I wouldn't want to serve on a board in this town if people aren't going to respect decisions that were made. 20 years later, 30 years later, you're saying, well, there's a problem here. You know, my clients didn't create the problem. They bought approved lots. You guys assessed them as residential lots. They paid you a lot of tax money. And I think you ought to consider those issues. And I think you ought to treat these people as, you know, the way the planning board treated them 30 years ago. Nothing has changed.
Sir, to answer or to rebut what you just said, the ordinance was put into effect in 77. You keep bringing up 75. The planning board did their job in 75 by going by the rules in 75 and before. Things changed in 77. I'm sure the town voted on this. People wanted the change. So to keep referring to 1975, and we should carry 1975 standards for 30 or 40 or 50 years, doesn't hold water. At least not with me.
Then
That's
why
just
did-
my
Then
opinion.
why did the town keep sending tax bills to these people?
Then they should have
Selling them
questioned
in
it.
residential lots and assessing them as
Then they should question it. Why should we wait for somebody for 30 years to decide that they're gonna come forward and say they wanna build now on a substandard lot? How long should we wait for these people to come forward?
Well, I mean, how are the Bouchers to know their lot? their tax
Then, you know,
bills paid?
ignorance is bliss, I'm sorry, but you know, you need to come and find out.
Okay. I respect your point of view.
And
we need to uphold the zoning board who built this manual in 1977. We can't go back to 75.
we can't say yes, I mean, to say no and then, and say yes. You know, we just can't say, you know, 100% is 100%.
Do we vote on each one individually? Or
Yes.
just, okay.
The same.
The need for a variance is due to the unique circumstances of the property and not the general condition of the neighborhood. How does the board feel about this? The unique circumstances of the property is that it's a subpar lot.
Well, the question is 5 and 6 for one person, owned by one person,
All three of them were owned by
all 3 by, and they were sold off after 77 as an individual lot.
one was sold,
One was sold and these 2 were,
yes.
Are we all done with comments?
Yes,
We're ready for a vote.
we're ready for a vote.
Vote on one.
Vote on one.
And would you like to word this is, have they met one or
Yes.
not met one?
Have they met one?
You want individuals or you want handshake?
Insurance?
I don't know.
Yes, do you agree that they have not? That let's see, the circumstance of the property is not the general condition of the neighborhood. The need for a variance is not due to the
And then I would just say,
it is
you
not.
want to take individual votes, make it
Yeah,
simple?
go ahead.
Okay. I vote that they have not met criteria 1 of section 10.04-2. We good with that?
Yes,
Beth?
I agree.
I agree.
I agree. 4-0, they have not met criteria number 1. Number 2, the granting of the variance will not produce an undesirable change in the character of the neighborhood and will not unreasonably determine the effect of the use of market value of abutting properties.
And I vote they met that.
It won't change. I agree.
Yeah, as it says, it won't change the neighborhood or the abutting property.
I agree with that.
If the granting of the variance, it won't.
I
Yes,
feel they've met that.
yes. The practical difficulty is not the result of action taken by the applicant or the prior owner. I feel that it was
I feel it was not the applicant, but the prior owner.
prior owner.
Prior owner.
Technically the prior owner, because it really, this was inherited down to the family and not the owner record at the time back in 75 or 77.
In
I'm
1975,
confused by
some,
the question, since you're posing it to us, I feel that.
No, we're just
We're just
speaking
talking
out loud.
It's just because the original owner is no longer with us, right?
it's like, it's the family and the estate.
Right, so the estate
Yeah.
was passed on, and we don't know what his mind was at the time or what he thought or cared about, which says. So it was technically the prior owner who did not do anything.
Yes. So they did not meet number 3.
Right.
3-1.
3-1?
I say they did meet it.
Okay. No other feasible alternative to a variance is available to the applicant. There is one.
Yeah, cool.
Could sell it.
No, they can't sell it.
Oh, okay.
Could they buy 5?
No one's gonna buy the lot they can't build on.
Somebody did.
Could they buy 5? 5 and 6, could
Somebody
they
bought a
combine?
lot after being told by town hall they could build on it.
That's hearsay.
But you know, that's like the 4th or 5th time you said that.
Hearsay.
And the question is, it is hearsay, you know this, Counselor, and also, the question that was presented to there, I have a lot here that was grandfather, 1977, you're looking at it, okay, and saying, is that grandfather lot? The question is, the lot is grandfather. Is it buildable? Who knows?
John, can you call the board to order?
Pull it back.
Yeah.
Code enforcement officer, was there a building application submitted for any of these lots?
We're not talking about that
No.
now, no.
John, can you call the board?
Because I'm looking for something.
What? Yes.
I'd like the vote on number 4, if we could.
Yes?
Yeah?
Yes. Go ahead. No feasible alternative to a variance is available to the applicant. Mr. Seer.
Not met. It did not meet number 4.
honestly say I don't know. Can I pass? Because I don't know for certain.
Sure, you can abstain.
Yeah.
Well, there is.
Because I don't know what they
there
can
is
do
a
and what they cannot
Should
do.
wait out at court.
They've not
So the
proven,
answer is yes.
in other words, whether they provided us the information for or against question 4.
Okay, with the information that I have, no. No, they have not.
They have not met number 4. How do you vote?
4 is no other feasible alternative to a variance available to the applicant. They haven't really met much. I don't know.
You want me to pass?
Huh?
Four? Did they vote?
Did he,
Not for it.
huh? You
No.
did?
Not that.
Not me.
Not met, okay. Number 5, the granting of the variance will not unreasonably affect the natural environment. They've met that. It wouldn't affect the environment.
Honestly, I don't know how it would affect the environment. We have 3 lots with 3 septic systems, well, I don't know how that would affect it. So I don't know. Mr. Seaver?
I would say they've met that. I don't have any alternative vote that they met that.
Yes,
I don't have any information that says they would.
that it would be any other,
Right, so
yes,
I'll
yes.
I'll
Yes,
vote
yes,
that they
yes.
met that with
Okay.
the information I
They have
have.
met that. And number 6, where'd you go?
Property is not located in a colon shoreline zone?
This one is not. So
This
they've
one is
met.
not.
What's that would be? Yeah, number 6.
That's a no-brainer.
That's a no-brainer.
Yes,
They met that one.
yes.
Matt?
Matt?
The board has voted on the 6 criteria, of which 2 were not met. Therefore, this part of the application is also denied.
Okay, thanks. At least you did it publicly, and we understand your point of view, even if we don't agree with it. I just wanted to address the administrative appeal. If you're willing to do so, avoid having to come back. It's a legal point. I sense from the board's comment, it's not going to get a groundswell of support from you folks. But I would like to preserve our rights to present this argument should we go down the road as part of our application, and I think we're entitled to at least put it on our presentation.
John, would you like to hold a vote whether we're willing to hear an administrative appeal?
Can we get a determination whether this is an interpretation or is this,
Part of the case.
It's not an appeal of any decision you've made. It's asking the board to interpret.
section 905, if that was interpreted?
We're going to
Well,
interpret
it's your
905?
interpretation, not if it was interpreted correctly, just what is your interpretation of it?
Is that 905? Of what?
It's to talk about the principle of estoppel and people that rely on information they get at town hall.
I don't feel we should,
That-
I feel that we have no jurisdiction on that.
No. That is not part of its ordinances.
I hear what you're saying. I don't agree with it, but if you want to vote not to consider it, that will put an end to it. I think you do have the power to hear it.
You want us to vote on a decision of somebody who was asked a question 5 years ago?
No, it was 2 years ago.
Or 2 years ago? You want us to,
I want you to hear them talk, not hearsay about what they did. I feel sorry for my clients who in 2004 wanted to buy a lot that was listed with a broker. And being prudent people, they came down to town hall and they learned that this 1 acre lot was in a 2 acre zone. And so they went back and said, what's going on? And they were told that because the planning board had approved it, it was grandfathered. And actually, there's language in your zoning ordinance that suggests that might have been the right answer. Section 208, which is the size reductions or increases, which is referred to in section 9 that your code officer talks about. Says in the last paragraph, in addition, any single lot of record, in effect, when any district created meets the existing requirements of state law, be used to construct, renovate, or reconstruct for primary use, in spite of the fact that otherwise applicable dimensional requirements cannot be met, except where the realignment of lots is possible. Well, when you look at the definition of lot of record in your ordinance, you've got a nice ordinance. It says a lot of parcel of land which is shown as part of an approved subdivision plan. So I'm guessing that the staff person, and I don't know if it was the current one or a different one, and I'm not here to say who it was, but the Zaharis will tell you about the conversation, and it's 2.08 seems to meet the standard. Now, the key is except where realignment of lots is possible. Well, we had 3 1 acre lots, zoning changed to 2 acres. There's no way to realign those lots to make them each 2 acres or anything other than what they were. So, I think there's support in your ordinance in this section 8, 2.8, for what the Zaharises were told. And I guess the town needs to decide, I mean, you can believe them or not, I'll let you certainly speak with them directly about it, but they wouldn't have bought this lot if they didn't think they could build on it. And the law says that when someone relies on some bad information, the town can't change its mind. Because it's just not fair. What else would you have them do? They came down and talked to your code people. They were told it's okay. They paid their money. There's a section in the ordinance that suggests it's okay. And I think you can read section 208, last paragraph, to suggest that these are lots created before the ordinance that are lots of record. And then the problem goes away.
Can I reply to that? If these lots were owned individually by individual people, Section 208 would apply. I'm not sure who spoke to the people when they were attempting to purchase this lot. Whether to know if it was told to us, if they were all owned 3 in combination by the same person. If that had been told to us, we would have said, Section 905 applies, which Section 208 refers to, Section 9, non-conforming lots. I don't know if they disclosed that when they, I'm not even sure they may not have known that they were all three owned by the same person.
Well, at the time they weren't. At the time, the Hurleys had already bought the lot near the camp in April of '04. So when the Harris case came down to town hall in summer, there were only 2 lots left in the Bouchard estate, not 3. And they were told, I think because of 802, or 208, excuse me, that they could build on it. And I guess you guys have the power to make that right. And there's an ordinance section that supports it. And I would hope this town would, I mean, we're not doing anything crazy here. We're trying to build on a 1 acre lot. It's twice as big as the state requires. And a lot that your planning board approved 30 years ago. And which has been developed, partially developed successfully. So we would ask you to consider that event. If you want to hear from the Harrises, I'm not sure which person spoke, but they can come speak to you if you want to ask them about it. And you can look at 208, and you're not changing anyone's decision, you're just agreeing with us that under 208 these lots are lots of record and therefore they can be built on. So that's our third request.
I make a motion that we do not consider this administration.
I'll second the motion.
All in favor?
Aye.
Okay, thank you.
Thank you. It's all over, Paul.
I'm sorry.